Okay, so this presentation is being recorded so that we can share it later with additional colleagues and SEIU 1 members. All of our participants today are going to be on mute, and there is a chat function, so you're welcome to put any questions or curiosities in the chat function. You can write in Polish, you can write in Spanish, in whatever language you feel most comfortable, and we'll be sure to follow up with you at the end or after the presentation. But I should have started. My name is Ellen. My name is Ellen Miller, and I work with this new training and legal fund. This week, we are very excited to have a series of presentations to make sure that SEIU members, Local 1 members, are familiar with the legal services supported by the Training and Legal Fund. Today, we are talking about estate planning, planning for the future. I went through the logistics right now. Again, I will make sure everybody is muted, and we hope you find this interesting. And to get us started, I'm going to share our slides as well. Just give me one moment to get this started. Let's see here. Okay. And now that we have our slides going, I would like to introduce the attorney of the day, Diana Mendoza Pacheco. Diana is the principal attorney of the Law Office of Mendoza Pacheco, LLC. She provides trusted real estate and estate planning services, and she's been doing this since 2013. She's been licensed attorney in Illinois since 2008 and is fully bilingual in Spanish and English. She's dedicated to helping families and individuals protect their assets and secure their futures with confidence. We are so lucky and so grateful to have Diana here with us for the next about 30 minutes to share information about estate planning. Thanks, Diana.
Thank you. Thank you so much for that wonderful introduction. I appreciate it. I will be speaking a little bit slower for the people that are listening to us in a different language. I want to make sure that our translators in the background are able to properly convey what it is that I'm saying. So if I do speak a little bit slowly, it is mainly because I'm trying to make sure that everyone has the benefit of getting this information. So thank you once again. I have been licensed for 17 years, primarily focused in estate planning and real estate. And I want to discuss some basics on what is estate planning, why do you need it, who needs it, how do you go about doing it, right? And where does it happen? So we'll be diving into the world of trusts as well and give you some pointers and some takeaways. So with that, I think we should just start into why or what is estate planning, right? So estate planning is the process of how you take care of your assets and how you plan on having yourself and your property be protected in the event that you are unable to do so, okay? Estate planning is a plan that literally takes care of yourself and your assets. It is not just a will. It is not just a retirement, right? I want to make it clear that estate planning is for any individual, essentially of any age, okay? So we're going to be discussing specifically typical documents that get included in that estate plan. It would be a will. We would probably include some powers of attorney, some healthcare proxies, which are essentially, and we'll dive into it a little bit more, but it's documents that go ahead and give your healthcare preferences. They get conveyed out by other people, not you, right? Because these documents are in place for when you cannot make those decisions for yourself. We will be discussing transfer on death instruments. That is another conveyance document. And again, I know this is a legal term. We'll dive into it a little bit more. But what estate planning is not, it's not exclusively for people that are wealthy. It is not a tool that is limited to homeowners or property owners. And it is most definitely not something that is a one and done, right? You cannot just do one thing one time and assume that you're covered forever because life changes, right? Because life happens. We can get married, we can have children, we can acquire and transfer property. Our lives are ever changing, and what works for us when we're in our 20s and 30s may not work for us when we're in our 50s and 60s and beyond. So let's move on to who, right? Because I'm kind of touching upon that, right? I'm sorry, why? Why should someone engage it? It would be protecting your family and your loved ones. So traditionally, people think I have to have an estate plan to protect my children, to take care of perhaps some special needs people in our lives. And that is 100% true. You can absolutely use an estate plan to protect your family and loved ones. It can also be to prevent disputes and court battles. When our lives, again, let's go back to our lives. Our lives are not necessarily always clean and cookie cutter. We may have issues with other family members, or we may have children from other marriages, or spouses, or ex-spouses, or whatever it may be. But when we have a plan in place, you can avoid your loved ones ending up in disputes or in costly court battles, right? We can also ensure that our wishes are properly respected by others when we're no longer able to speak up. So a brief example, someone is in an unfortunate accident. Just say a car accident. We all get in cars on a daily basis, right? And you end up in a state of coma. Who is going to be speaking for you? A lot of people will assume that their spouse or their parents or their children will automatically have a say, and that is not always the case. And then when you put things in writing, again, it avoids issues. You may have a very loving parent who may have a harder time taking difficult medical decisions as opposed to another family member. And now because of them arguing, your wishes are not taken into account. The estate plan will provide a peace of mind and legal clarity. So peace of mind for everyone involved, both yourself and your loved ones, and legal clarity. So for all of you. Now, we've already spoken as to who can benefit. If you have children, if you have property, if you have savings, absolutely have a plan in place. Anyone that is wanting to have that voice or that control, you need to have this document. And it does not matter the type of family that is involved, right? You don't have to have children, again. And your income level is not a factor into this because you and yourself need a plan in place, regardless of whether you have $1 million coming in or or 30,000. It doesn't matter. So who is it not necessary for? Here's the trick. Everyone should really have it. But if you truly have no assets, think about that for a second. That means like no bank accounts, no cars, no anything. So if you have no assets and no dependents whatsoever, then I guess in theory, is it really necessary? Probably not. But generally, most of us will have something or be concerned about someone. But okay. Um, let's see here. Now, when do we start? This is a key question. It absolutely needs to be started before you actually need it. Okay. I'm going to break into a quick example. I have had people call me after a loved one is already in a coma, and they ask me about, can we have a power of attorney so that I can communicate with the mortgage company and help them out with their payments? They won't give me any information. Well, if the person is already in a coma, it's too late. Um, there are still ways to do it, but it becomes much more complicated. It most definitely, you're going to need to have an attorney. They're going to have to show up in court, do legal proceedings. What should become a simple document becomes a very complex legal proceeding. So you need this before you actually need it. um, I've had other people also try to navigate the world of how do we distribute my loved ones' assets now that they've passed away. And again, if there is no plan in place, it becomes much more expensive. It becomes much more stressful. So definitely do this before you actually need it, which is probably sooner rather than later. Um, how? Does this estate plan work? Well, first, you definitely should speak with a competent attorney. Okay, have a consultation because every set of facts will definitely affect the type of documentation that needs to be prepared and the type of plan that comes into place. I mean, estate planning is not just a label; it is literally a plan. So some people will have a will, others will have a powers of attorney, others will have healthcare directives or proxies, and then this world of toddy. So we're going to get a little bit more specific here. I don't recall if I got into specifics on the other slides, but I'm pretty sure this is probably the best way to go ahead and address this. Yeah, let me see here. Yeah, I think this is the best point. So a will. A will is your testamentary decision. So it is me, I, upon my passing, wished to give my property to my husband, my wife, my children, my friend, my neighbor, whoever it is that you choose, right? And that is your last statement as to how your assets are going to be distributed. But it kicks in upon your passing, okay? You're not actually conveying anything while you're alive. The powers of attorney, that it's actually a term that encompasses two different types. You have your powers of attorney for healthcare, and you have your powers of attorney for property. One power of attorney is geared towards your assets while you're alive. Remember, a will is after you pass. A power of attorney is while you are alive. So in the event you end up in a coma, or if you have to dress in, from one moment to the next, leave the country and you need someone to manage your affairs, a power of attorney is a document that allows a person to act on your behalf while you are still alive, okay? As to healthcare decisions and as to property decisions, right? A healthcare proxy is also the same way, but it can be different types of documents involved, and your attorney is the one based on your conversation and consultations with them that can include these additional documentations that can be so specific as to I don't want to be artificially kept on a ventilator if something happens to me. Or if I pass, I don't want to be buried. I want to be cremated, right? So there are different types of things that through an estate plan can be done, and that is why it is essential that you have a consultation with an attorney to discuss those. And then also a toddy. It's a transfer on death instrument. That's what TODI means. TODI is short for transfer on death instrument. That is very different from a quitclaim deed, by the way. Okay. And again, this is where speaking to an attorney is key. A transfer on death instrument is a document where you say, I, upon my passing, will give my property to, and you can say who it is that is going to receive your property, and it gets signed like a will with all of those features, and it gets recorded with the county. So you in life are recording that conveyance document while you are alive, but it takes into effect when you pass away. Okay. So it is like a hybrid of a will and almost like a quit claim, right? And by the way, without getting to specifics, that's how you transfer property. So with a toddy, you can actually say who is going to be getting your property upon your passing, sign it very similarly to a will, and have it recorded with the county so that upon your passing, your heirs, those people that you name there, can take that property. It's a way to avoid something called probate, which again is a whole nother discussion. But it is a mechanism by which you can transfer property that may be a bit more effective than a will, depending on your situation. Some of these documents require notarization, other documents do not. Your attorney will definitely guide you through all of that. And all of this process, from consultation to delivery of documents, can be done in a matter of weeks. So please, again, this goes back to do not leave it to when you need it immediately, right? By then, you are probably doing yourself a disservice. You definitely want to get started when you have plenty of time to do it. Okay. So where do these documents get done? Most of it can be done at your attorney's office, right? But the process gets started virtually. So every attorney handles these in a different way. Me, for example, in my practice, I will usually have consultations be done remotely, and we will then, once we connect as far as gathering information, there will be questionnaires, lots of phone calls that may happen beforehand. We will have a plan in place based off those consultations and have a draft ready. Usually we meet in person as we go through these drafts. I want to make sure that in person we look at these documents before we make minor tweaks here and there. Almost always little minor changes as we're sitting down going through them tend to come up. And then we'll have, after that draft is revised, we'll have probably a second meeting where it's called the signing. These wills can be signed, again, at your attorney's office. They can be signed, some of them can be signed in financial institutions. Honestly, some of them can even be signed at your home, right? I've had mobile notaries attend people's homes if it's much more convenient for them and their loved ones, if there's mobility issues or transportation issues. And a mobile notary can actually get all these documents signed and notarized. So where exactly it happens is part of the plan and a discussion that you need to have with your attorney. Now, trusts, we can have a whole hour discussion as to trust, but we're not going to do that. But trusts in general is a legal arrangement where one party, right, so you, go ahead and convey over to someone or the trust, right? And you have another entity manage it. So the key words here are grantor, a person who creates a trust that, assuming it's you would be the grantor. A trustee, a person who is to manage the property that is in a trust. And that can also be yourself, or it could be someone else, okay? And a beneficiary, who is to receive the benefit of that property. So the best way that I can explain is it is like a treasure chest, right? So you are putting your money, your assets, your house, whatever it is that you wish to put, you are putting it in this treasure chest. And then you are the grantor, you're establishing it. And then you get to decide who manages, who protects that treasure chest. That would be the trustee. It could be yourself if you're alive and capable and wish to do so. Or in that document itself, in the event you're not able to, you can say someone else can manage this treasure chest, right? But here's the kicker, the person who manages it is not necessarily the person who owns the treasure chest. That would be the beneficiary. So this treasure chest can be managed by you and it can be yours. You can both manage it and own it, or it can be managed by a close relative or trusted family member, but it is for the benefit of, say, your children who are minors, who are still yet to grow. And in the event you pass away, you want someone to help them take care of this treasure chest with all of these assets that you put into it. So I think that's the best way to kind of break down, I think, a very complex idea of what a trust is. Why? We talked about probate for a little bit, just a little bit. And without going into too much specifics, probate is a judicial process by which you present your testamentary will and say, this is who I want to get X, Y, Z, A, B, C. As you can see, anything that is judicial in nature will usually be much more complex. Your loved ones, which once they have the will, may have to hire an attorney. They're going to have to go through the probate process, can take months, okay, and several $1,000s later. So avoiding probate is definitely something that a lot of people want to do. It can also manage your assets while you're alive. Again, if we do not know what is going to happen tomorrow, a week from now, a month from now, 2 years, 5 years, 10 years. We do not know if we are in a difficult situation where we either are unable to make decisions for ourselves because of accident or illness, or maybe we're unable to make decisions for ourselves because we have to leave the country from one moment to the next, or are caught up in other affairs. For whatever it may be, other people can manage those assets for you while you're not capable of doing that. It also can protect minors or people with special needs. Again, these trust documents can go ahead and manage this treasure set, these assets for your children, not even until they're age 18. You can do it until they're 20, 25, 30. You can parent literally from the grave, okay? And you can take care of perhaps adults in your life that need special care. So even though they may be adults, you may say, you know what, they might need a little bit of assistance in managing this. So it gives you control, in control of what it is that you're giving to others. Final tips. So once you have all of this in place, once you have actually had these conversations with an attorney, you have this wonderful piece of plan, review it and update it as needed. Now, your attorney will try to have this document be as mutable as possible, meaning as changing with you as we can. But there are certain life events that will trigger your need to speak to your attorney. You get married, you have children, you have a house for the first time, or you're selling and have acquired investment property, whatever it is that that may be. Those are points by which you need to go ahead and review and update that. You also need to have conversations, sometimes difficult conversations with family members. Even though you have this wonderful plan in place, it would be nice for you to let those trusted individuals know, hey, this is what I've done, and I've asked you to please be part of this. And definitely keep these documents in a secure location. You don't want to hide them so well that no one can find them, okay? And I would strongly encourage you not to keep this a secret. Again, those individuals that are going to be charged to help you manage this plan, please try to have a conversation with them and let them know where they can find them when they need them. And then last but certainly not least, please, please, please talk to a licensed professional, talk to an attorney to guide you through this. These documents are so important, and they should, in my opinion, not be a DIY project. You should not be doing this yourself. But I think unless anybody has any questions, well, no, I don't think we have a time for questions. I'm not sure, but there's some information on how to connect. Thank you. I can't hear you, Ellen.
Here we
Okay,
go.
now. Yeah.
Slight technical difficulty. Thank you so much for that really, really useful and interesting information. And I think what's important to highlight here is that this process, well, so Diana talked about a few things today. She talked about wills, power of attorneys, and toadies, right? These benefits are all available to you free of service, free of charge. Okay, these services are free of charge. You can connect with an attorney, and this fund, this training and legal fund, will pay for these services for you. All you need to do is contact us, and we will connect you with an attorney to help you through this process to have a consultation. Regarding the trusts, we put in information about trusts because people have been asking about it. At this point, because this is a new fund, we currently do not financially support the trust, but you can consult with your attorney, and we would just want you to know that that is an option if you choose to pursue it. So again, the wills, powers of attorneys, and the transfer on death instruments are available to you free of charge because you're a member of these contracts at SEIU Local 1. You need to call the number on your screen, which is 312-233-8794. So you call that number, you get a hold of us. You can also talk to your local organizer. Whoever is your organizer, your point of contact with the union, they can also be in touch with me. And so again, it's 312-233-8794. There's also an email if you prefer to email us, and we will connect you with an attorney. That's all for today, but I will say that tomorrow we'll be talking about real estate and buying and selling a house. And Thursday and Friday, we have additional presentations. We hope you can join us again tomorrow at 11:30. And Diana, thank you again for all that you're doing for our communities and for being available to us today. Diana is one of our attorneys that's working with the fund and available to help you and your families get organized. So Diana, thank you so much.
My pleasure. Thank you.
Yep, and everybody have a wonderful day.
Thanks.
Bye-bye.